In today's video, I wanted to go over Melendez-Diaz v. Massachusetts. It's an evidence case dealing with the Sixth Amendment. The facts: the defendant was arrested while making a drug sale in the parking lot. At trial, the bags of drugs alleged to have been distributed by Melendez were introduced into evidence along with the drug analysis certificate prepared by the lab technician who analyzed the drugs and identified them. A jury convicted Melendez-Diaz of distributing and trafficking drugs in violation of Massachusetts law. The defendant appealed and argued that the state's introduction of the drug analysis certificate violated his Sixth Amendment right to confront witnesses against him under the court's ruling in Crawford. In Crawford, the court had held that so-called testimonial evidence cannot be introduced at trial unless the defendant has a chance to cross-examine the witness providing the evidence. Melendez characterized the lab analysis as testimonial and argued that Crawford required the lab technician to testify on the results. The state, on the other hand, argued that Massachusetts had previously held in Commonwealth v. Verde that the lab reports were not testimonial in nature. The question before the court was whether the forensic lab report prepared in the criminal trial was testimonial evidence in nature. And the answer is yes. The Supreme Court held that a state forensics analyst report that is prepared and used for a criminal case is subject to the Sixth Amendment Confrontation Clause. The court reasoned that the lab reports constitute affidavits which fall within the core class of testimonial statements covered by the Confrontation Clause. Therefore, when Melendez was not allowed to confront the person who created the lab reports used in testimony at his trial, his Sixth Amendment right was violated.